Welcome to the inaugural episode of Pod Save Our History. I'm your host, Jonathan DiCarlo. Pod Save Our History is a podcast about the nexus between American legal history and African American history. Today I'm going to be introducing a three-part episode about the history of the Supreme Court. Many of us that follow the Supreme Court closely are familiar with the breaking news segments that immediately follow the court issuing key opinions, with legal analysts trying to sift through a 50-page legal decision live on cable news. This was something all too common in recent months as the court released key opinions from its 2020 term. From the third challenge to Obamacare, to the Fulton case about LGBTQ adoptions in Philadelphia, to one of the last cases of the term, Brnovich, where the court all but killed the Voting Rights Act. You may have noticed how integral the court is to the functioning of the other two branches of government. The Congress and the White House often rely on the court in their legal fights to pursue or block a given presidential administration's agenda. Take, for example, the Trump travel ban, or the citizenship question for the 2020 census, where various groups sought to block obviously racist Republican policies. In those cases, the court was the final arbiter to settle disputes. Throughout its history, the court as an institution, with its liberal, moderate, and conservative justices, has sought to elevate itself to the stature of the Congress and the Presidency, and even beyond. But the Supreme Court, which represents the judicial branch of the United States government, was not always front and center. As a matter of fact, when the court was established, no one wanted to be on it. Lawyers and judges recoiled when they were asked to serve on the court. There were no contentious confirmation battles. There was no Supreme Court building. There were no plans to create one. On the court's first day, there were not even enough justices who showed up for work to establish a quorum. The court was, at best, the child of two parents jockeying for power, the legislature on the one hand and the executive on the other. This all began to change around 1800, as the young United States of America, its people, and its system of government were headed for a major test in ensuring its continuance. This change centered around the election of 1800, the fourth presidential election in American history. The election of 1800 represented a pivotal moment in early American history. This is because this was the first time that political power, both in the Congress and in the Presidency, was handed over from one party to another. In this election, the Federalist Party lost control of the Congress and the Presidency to the Republicans. Now, it's important to note that the Republican Party in 1800 is not the same party as today's Republican Party or today's GOP. The Republican Party of 1800 was also known as the Democratic Republican Party, and the Republican part of its name was dropped under President Andrew Jackson in the 1830s. The Federalist Party fell apart after its losses in 1800 and reunified under the new Republican Party when Abraham Lincoln was elected in 1860. This was the first presidential election in which parties had a platform and a ticket. Prior to this, the candidate who had the most electoral votes became the president, and the one who had the second most became the vice president. This is why Thomas Jefferson, who was the main opponent to John Adams in the election of 1796, became his vice president. In the election of 1800, John Adams and Charles Pinckney of South Carolina ran for the Federalist ticket, and Thomas Jefferson and Aaron Burr for the Democratic Republican ticket. This was still very different than what we know today, because there was no real distinction between who was running to be president and who was running to be vice president, other than any potential agreements between the two candidates of a single party. This process was advantageous to the Democratic Republicans in this election, for example, because while Thomas Jefferson was very popular in the South, including in his home state of Virginia, which had 21 Electoral College votes, Aaron Burr was popular in New York, which had 12 Electoral College votes. So this setup allowed for the candidate to spread out their popularity throughout the country. This is similar to what we have seen in recent history, where a candidate like John F. Kennedy selected a Southerner, Lyndon B. Johnson, as his vice presidential running mate, because he was from the South. But in 1800, there was no clear distinction about who was going to be president and who was going to be vice president. The Constitution did not specifically direct electors with regards to casting votes for the president or the vice president. This was changed with the 12th Amendment that was ratified in 1804. But for the 1800 election, electors representing states that the Democratic Republicans had won were not required to vote for one of the two candidates specifically for president versus vice president. This resulted in some of the electors voting for Jefferson for president, while others opted to choose Burr for president. This caused a tie in the Electoral College. The Democratic Republicans initially planned to give Thomas Jefferson one extra electoral college vote so that he would become the president and Aaron Burr would become the vice president. But this strategy didn't pan out. The Constitution provides for a solution to a tie in the Electoral College, which is a vote in the House of Representatives, known as a contingent election. The way the votes are tabulated in the contingent election is quite different from the Electoral College. In the Electoral College, the number of electors that each state gets is determined by the number of seats that it has in the House of Representatives, plus the 2 seats that it has in the Senate. In a contingent election, each state is given one vote, and a candidate must receive a majority in order to win the presidency. What made this tie in the Electoral College even more unique was that the Federalists, who had control over the Congress in the previous congressional session, had lost power in the election, but they were still called upon, per the Constitution, to choose the new president of the opposing party. This gave the outgoing Federalist majority some political leverage in negotiating and maneuvering this contingent election. Until 1933, the new president would always be inaugurated on March 4th, which extended the period between the election and the beginning of a new administration, sometimes known as a lame duck session. This date was changed from March 4th to January 20th with the 20th Amendment that was ratified in 1933. In the new year of 1801, the House of Representatives engaged in the process of voting for the new president. This whole process was very fascinating. I'm not going to get into it in great detail other than to say that beginning in February, the Congress initiated the contingent election and they cast 35 ballots in which neither Jefferson nor Burr received a majority of the votes. There were 16 states at the time who all had one vote each, so in order for a candidate to receive a majority of the votes, they needed to have 9 states vote for them. On February 17th, the 36th ballot was cast and Jefferson won votes of 10 states. Aaron Burr, who was competing with Jefferson for votes in this contingent election, became the vice president during Jefferson's first term from 1801 to 1805. Thomas Jefferson would later refer to this period in history as the Revolution of 1800 because it was the first peaceful transfer of power from one party to another. But was it really a peaceful transfer of power? There was indeed a revolution happening, but it was happening quietly in the executive branch. While the House of Representatives was busy holding this contingent election, John Adams and his Secretary of State John Marshall, cousin of Thomas Jefferson, were trying to solidify Federalist power elsewhere in the third branch of government, the federal judiciary. In the closing days of his administration, President Adams filled federal offices with loyal Federalist appointees. This included judges across the country and in the 2 newly established counties making up the District of Columbia, Alexandria County and Washington County. The bill also removed the requirement for Supreme Court justices to ride circuit. This was a practice in which Supreme Court justices were required to go to specific court districts and sit with the trial courts. Riding circuit was a key reason why being a justice on the Supreme Court was not appealing to many lawyers and jurists at the time. Sometimes today we hear commentators say that we are now in the most divisive, partisan time in our history. But if we go back to this era, this Judiciary Act of 1801 was passed with no support of the Republican Party, and even a few Federalists joined the Republicans in its opposition. It passed the House by a 51 to 43 vote, and in the Senate by a 16 to 11 strictly party line vote. This bill passed in January and February of 1801 and was signed into law by President Adams on Friday, February 13, 1801, which was just a few days before Jefferson was chosen as president in the contingent election on February 17th. One of the key examples of the judgeships that this bill created was the newly established Federal Circuit Court that established 6 courts and 16 circuit court judgeships. This move was criticized by the opposition party and the Republicans that were coming into power in the Congress and in the presidency. Specifically, a Virginia congressman named John Randolph mocked President Adams for making the judiciary, quote, a hospital for decaying politicians. So we can see here that there is strict partisanship, there's politicization of the judicial branch of the United States government. All of the new judgeships that were created by the Judicial Act of 1801 that President Adams signed into law on February 13th were filled by February 24th, just 11 days later. Unlike today, there were no hearings for judicial nominees. The constitutional requirement was merely that the Senate provide advice and consent, and so the Senate merely voted on the appointees. The Congress then helped Adams further solidify Federalist control of the judicial branch when the Congress passed the Act concerning the District of Columbia. It was signed into law on Friday, February 27th. This law established 3 new judges and a bunch of offices for the new District of Columbia. But in order for Adams to get loyal Federalists in these positions, he and John Marshall had until the following Wednesday, March 4th, to nominate dozens of appointees, get them confirmed by the Senate, and importantly for our story, to deliver commissions to the appointees before the government was turned over to Thomas Jefferson at the inauguration on March 4th at noon. On Monday, March 2nd, President Adams submitted the nominations of 42 justices of the peace and several other individuals nominated to legal positions. The same day and the following day, Tuesday, March 3rd, the day before Jefferson was to take office, the Senate considered and confirmed the appointees. Once the appointees were confirmed, John Marshall, the Secretary of State, was responsible for countersigning the commissions and delivering them to the confirmed nominees. One of the clerks for John Marshall was responsible for delivering the commissions, but he forgot a bunch of them, and John Marshall did not catch this error in time for the inauguration. The commissions that weren't delivered were for Robert Townsend Hoe, William Harper, and Dennis Ramsey, who were to be justices of the peace in Alexandria County, and William Marbury, who was to be a justice of the peace in Washington County. The undelivered commissions were discovered 2 days later at the State Department by the President Thomas Jefferson, who would later acknowledge that he refused to deliver them, believing in a legal doctrine that delivery was essential to their validity. It was clear that he was very frustrated with John Adams, who he believed was packing the judicial branch with Federalist loyal nominees in order to restrict the changes that the Democratic Republicans would bring to the United States government. Jefferson wanted to eliminate any semblance of monarchical or aristocratic rule that he believed characterized the Federalists. While Jefferson didn't make any changes to the appointments that Adams made or remove any of them that were within his power, such as attorneys or marshals, he did limit the number of justices of the peace in the District of Columbia from 40 under Adams to 30. And with this, he withheld the undelivered commissions that include the commission of William Marbury. On Wednesday, December 16, 1801, Charles Lee, the former Attorney General, appeared before the Supreme Court on behalf of the 4 individuals who had not been permitted to take their offices as justices of the peace because their presidential commissions were not delivered. Lee requested a judicial order from the court that would compel the executive branch to action, which is known legally as a writ of mandamus. On Thursday, December 17th, Lee presented his motion to the court on behalf of Marbury and the 3 other plaintiffs. James Madison, the new Secretary of State, did not pay attention to the case or have the executive branch represented before the Supreme Court. The court ordered Madison to show cause and explain why the court should not issue a writ of mandamus to compel Madison to deliver the commissions. As a result, the Supreme Court scheduled arguments in this case for June of 1802. This move by the court was audacious. It brings us to the second theme of this opening series, which is the place that the Supreme Court, and more broadly the federal judiciary, was to occupy in this new federal government. We don't have to go back very far to see evidence that the Supreme Court was not really esteemed to be on an equal playing field with the Congress or the President. When the District of Columbia became the capital in June of 1800, the President's house in the capital still remained unfinished, but the commissioner responsible for laying out the capital city had skipped over any planning and or construction of a Supreme Court entirely, recommending that the court use 1 or 2 rooms in the new executive or war offices. The room the court ended up using, Committee Room Number 2, located in the Capitol, was very small, and the court was required to share the room with local District of Columbia courts. This lack of planning for a space in the District of Columbia for the court itself reflected that it was, in the eyes of many, a lesser branch of government. This wasn't a secret. 5 of President Washington's original 6 appointees left the court when Washington died, and the Chief Justice at the start of 1800, Oliver Ellsworth, avoided the court by spending most of 1799 and 1800 in France as a representative of President Adams. But this began to change when John Marshall became Chief Justice. He helped to unify the court and amplify its voice to make it look strong and decisive. So when the court decided to hear the Marbury case, it represented a pivotal moment in determining the scope of the court's judicial power, because the court was placing itself in confrontation with the executive branch through Marbury's petition. In next week's episode, I'll be going through the Marbury case, including all of the history and the politics that were involved in it, with an eye towards how the short-term and long-term consequences helped shape the court into a dominant branch of federal power. Thank you so much for listening to this episode of Pod Save Our History. This podcast is a public history project, and its goal is to make history more accessible to the public so that each person is able to have a better understanding of where we've been and how that influences where we're going. I'd really appreciate it if you can take the time to post a review on whichever podcast platform you're listening on. You can also share this episode with your friends and your audience on social media. I really want to get the word out about this podcast, so if you'd be willing to share it directly with 1, 2, or even 3 close friends by sending them an email, a text, or a direct message, I'd really appreciate that. If you want to be kept up to date with the podcast, my research, and any other projects I'm working on, you can go to jonathandicarlo.com and sign up to my mailing list. I send out a monthly newsletter about my research and about issues in politics that have a specific link to American history. You can also follow me on Facebook, Twitter, and Instagram. You can follow my YouTube channel for some additional content. All of those links are in the description of the podcast or on my website, jonathandicarlo.com. Don't forget to hit the subscribe button for the podcast so that you're updated on all of the episodes which are released every week on Tuesday. I'd also love to hear any feedback you have about the pod, which you can do by sending an email to jonathan@jonathandicarlo.com. Thank you so much for listening. I'll see you next time.